We are going to have a conversation about the practical aspects of proportionality and the use of the guidance. It was an honor to work on these guidelines with Jenny and everyone who contributed to them. And I do think a review and understanding of them will make the use of proportionality, which I believe both Jenny and I agree is a really fundamental cornerstone for doing discovery well, more practical for everyone who has to participate. We've sort of broken it up into a group of discussion points that I think we'll just trade off. I'll go first, and Jenny will then bring her view in, and then she'll go, and we'll go back and forth that way. I will say I feel a little intimidated having have to follow our three prior speakers, but I think we can do our best to try to illuminate this area from those of us who do, I think, the vast majority of this out of sight of the court, which is what they want. If you look at what everyone just said, you know, in the spirit of cooperation, the story that was just unfolded is the vast majority of these conversations that we need to have about what should be produced and how it should be produced and the extent to which it should be produced. If discovery is done well, it'll be done most cost effectively when counsel get together and meaningfully discuss these issues and come to amicable resolution, and only bring forth those disputes that can't be settled because of a principal difference in the scope of discovery or what is proportional to the needs of the case. And so I think the 6 items we're going to talk about really focus on that. I mean, Jenny, would you agree with that?
Absolutely. Absolutely. And I think we're going to start our discussion with bullet point 1, and we're going to try to keep things somewhat truncated, but there's going to be a lot of overlap, I expect, as well.
So why don't I start with that point? Right. And I think that's because there is on both sides, the requesting party and the responding party. And for this discussion, I'll be the responding counsel, even though, you know, as I do a lot of requesting. There is a real need, if you're going to use proportionality as a response and as an objection, as Judge Grimm really pointed out, you need to do your due diligence. And we're going to talk about the level of due diligence. But what I think of when I'm either requesting or responding is that I'm starting a conversation with my opponent about whether what I need or what I'm willing to search for with respect to discovery. And that sort of sets the metes and bounds of the conversation that's going to follow and the cooperation that will be needed to get to hopefully an amicable decision about both sides can agree, yes, that's what I need, and that's what I'm willing to accept that you're going to produce. As a responding party, I think it's crucial not to use boilerplate. It's crucial to be using facts, not assumptions. And the way I when I discuss this with my own team, I always want to use the word because. I can't produce this, or I don't think I should have to produce this because it's disproportionate, maybe the need beyond the needs of the case, or you know, incrementally the marginal cost is greater than the marginal benefit because X and Y, so that my opponent can see that and understand where I'm coming from. If I use mere boilerplate, that doesn't help move the ball forward. There's no way for them to have any transparency into what I'm thinking. And so the conversation is sort of stays flat. The other 2 things I'll just say before passing the ball is I always focus on what I'm going to be searching for because I don't know what's going to be in the data, right? Often these requests and these responses happen very early in the case. So I'm trying to direct my opponent that this is what I think you want and this is what I'm willing to search for in the data. The other thing that I tend to do is I don't mind having longer objections if I'm willing to explain the because and provide some facts. It's not an affidavit, it's not a brief, but it helps get the conversation going. And what I will often do is start the objection with what I'm actually going to do. What am I going to produce? In bold, so that there is a clear understanding. I'm not just putting the boilerplate that everyone despises, pending my general and specific objections, I will produce responsive documents that are not privileged. I don't think that's helpful and doesn't push proportionality to the forefront.
Thinking about these issues, the role of proportionality in seeking, drafting, and responding to and objecting discovery, a couple of different perspectives come to mind. First, with respect to document requests and discovery requests generally, I think it is important for the requesting party to really sit down and think about what are your claims in the case and what are the elements to those claims. And that's an important exercise, not only because it will result in proportionate discovery, but it will also ease the meet and confer process a great deal when you've already thought about why you need the information you're seeking and you can articulate that. And it will also, to the degree you get pushback on that discovery, it gives you a foundation to go to the court, and you'll have a reasoned foundation for seeking that discovery. That said, I think that there have been some, with our work on the most recent draft of the guidelines, I think there's some important acknowledgements about this issue, and most importantly, that broader discovery requests are not necessarily disproportionate. And one of the additions to best practice number 6 acknowledges that pressure on the requesting party to begin by seeking and requesting only discovery that would be non-objectionable and all parties must agree should be produced, or on any kind of phased discovery, is this fear that they're going to be denied additional discovery later, and that delays on the initial discovery may prevent, from a time perspective, additional follow-up discovery later. So I think there's an important addition in the best practice number 6 that I'd like to point out for everyone's benefit. It says, in a case in which discovery is likely to be voluminous or complex, the parties may choose to serve robust discovery requests, taking into account the proportionality factors, followed by discussions or orders that focus on the immediate production of the most important information first, but allowing the parties and the court to prepare a larger discovery plan. This would avoid a situation where a party agrees to serve requests for a more limited discovery or for more limited sources, is forced to engage in protracted negotiations and motion practice to obtain that discovery, only to face arguments that additional discovery was not contemplated or that multiple productions are unduly burdensome. I think that this issue was a issue of great concern for the plaintiff's bar, which is frequently the requesting party, both with respect to the amendments to the rules and that process before the Rules Committee, and also with respect to the proportionality guidelines. So I think that's a very important addition to the best practices in the most recent round. On the other side, you have the role of proportionality in responding to discovery. And as we know, the amended Rule 34 emphasizes the obligation to respond with specificity and prohibits the type of general boilerplate objections that David was talking about. It also requires the party to state whether documents are being withheld and the basis of those objections, and to state when discovery will be completed. Now, I know the last issue is one that raises a lot of objection from the responding party, especially in very large cases, because sometimes it is difficult to, in your initial responses, to say when your discovery will be complete. But in many cases, that is doable, and where doable, it should be addressed, and where the responding party feels that it can't be addressed, they should be prepared to discuss what a reasonable timeline would be, even if it's incremental. In addition, since we're focusing on the most recent revisions to the guidelines, another important addition with respect to guideline number 5 which addresses this issue that the amended rules do not authorize boilerplate and blanket objections on proportionality, is the acknowledgement that the amended Rule 34 has a purpose not only for figuring out what the objections are and what's being withheld, but also to determine where the parties agree. And that's an important addition to the guideline number 5. And the addition reads, when a party objects with particularity to producing some discovery, but agrees to produce other requested discovery, the party should discuss the timing of the production of the unobjectionable discovery to determine whether agreement can be reached to begin that production even before resolution of the objections. I think that's important, and it's something that can only happen when the parties are really looking towards proportionality and really focusing on the goals behind the amended Rule 34. And that's important because once you can get the discovery rolling with respect to materials that aren't objectionable, that's going to reduce long-term delay, and it's also going to instruct the parties in their negotiations over discovery where objections may be made and discovery requests may need to be curbed. I'm going to move into some of the issues about bringing proportionality controversies to the judicial officer, bullet point number 2. I think that one theme in the guidelines that both parties on each side of the V and a lot of judges agree is important is this concept of greater judicial involvement in the discovery plan. Now, that is not to say that you want to burden your judge or magistrate with every tiny little dispute. The parties, as David mentioned, need to do their work, and that's why it's important to tee up issues in a thoughtful way. But I think the guidelines encouragement for judges to have live and regular case management conferences is an important one. And that's an important one, not only for the judge to keep track of whether discovery is getting stalled, but also for the parties to continue to touch base on where they are on larger discovery issues. It's also in the case management conference statement is a great place to start teeing up issues before the court that maybe aren't completely ripe, but to give the court an idea about where the parties are in agreement and where they see some issues arising down the road, even if they aren't completely ripe for resolution before the court. And that can oftentimes allow the judge to give some guidance early and prevent delay in that respect. As far as raising these controversies, again, it's very important for both parties to remember their obligations under the discovery rules, because that's going to narrow the discovery disputes and make them easier for the judge to resolve. So, for example, the greater the responding party has articulated, and with greater detail has articulated their objection and really articulated, as is their burden, why they believe any discovery requested is not reasonably available, the better their argument is going to be for resisting that discovery and perhaps convincing plaintiffs' counsel that the discovery needs to be curbed or that a compromise needs to be made. Again, boilerplate objections just aren't helpful. And not only are they not helpful for resolving the issue between the parties in the court, but it also can raise a lot of suspicion between the parties, which is unhealthy and going to cause delay and anguish throughout the case. And in these larger cases, that can be sometimes years of relationships. And then on the other hand, again, being able to really articulate on the responding party's side why you need the discovery. And again, going back to a comment that Judge Rosenthal made, this is critical for not using boilerplate discovery. You really need to think about what are your claims and what are the elements. And once you've done that, discovery is going to be so much easier, and raising these issues with the court is going to be easier. And the last thing I would raise that I think David will probably agree with is we really appreciate it when judges have a truncated approach to discovery disputes, where there can be informal letters or conference calls made at the outset of the discovery, as opposed to having to tee up a formal motion to compel, which can delay things by months. I find that usually those conference calls and letter briefs resolve the dispute and allow the parties to move forward with an eye to, with knowledge of what the judge is thinking is going to be reasonable versus not. But David, what are your strategies as far as bringing proportionality controversies to the court?
Thanks. I mean, and your last point, I think I do agree with. I will sort of, as Judge Peck said, there are different types of disputes that require a different level of briefing. And so some disputes, I think, can be addressed sort of in a more truncated fashion, but others require full briefing and may get pulled up to circuit court, mandamus, and even higher levels of review, things like cross-border discovery, possession, custody, and control issues around the production of non-responsive documents, privilege issues. So I think it does depend, but some discovery disputes do lend themselves to more truncated discovery schedules that enable the parties to understand the metes and bounds and allow the discovery to go forward. And this actually, I'm just going to return to something you said about the last session, because I think it's on the same point, which is there are times where it's appropriate if we can move some discovery forward ahead of other discovery. It may help the parties resolve whole issues or help them understand what else incremental discovery needs to be done. Sort of the phased approach, which is absolutely part of these guidelines and something that is widely adopted. That being said, sort of returning to the same data source over and over again, looking for now new and different things, does dramatically increase the cost and can make it disproportionate. So where parties can reach agreement holistically on all of the issues around a single data source, I think that can be cost saving and therefore more proportionate. And on the boilerplate, I agree. Boilerplate objections are anathema to good discovery practice. That being said, not everything is boilerplate, right? In the sense that if I have a opponent who has defined my client to be not only that client, but anyone they've ever met in any degree, whether former employees, predecessors, whatever, it doesn't make sense for me to object to that in every single request. One single objection stating in a clear way why I'm defining who has possession, custody, and control, I think is a helpful way of teeing that up for further discussion, and if necessary, discussion by the court. When I think about bringing things before a judicial officer, I want to make it as easy for that decision maker to understand my position as possible. And it's really important that it be grounded in facts, not assumptions, that I'm prepared. I find that the worst advocacy done by discovery lawyers is when they don't truly understand the nature of their objection and are just winging it or making general conclusory statements. That doesn't mean you need to bury the judge in paper. That is probably not going to win you any favors. I often think if I'm arguing a proportionality issue, I will condense it down in my briefing and maybe have an appendix. So if they really want to get into the weeds as to the underlying data and facts that I have. And if it's a truncated matter, I may not have that on the initial round. And if it becomes a point of contention, bring up additional facts later if it's appropriate. Not always appropriate. You sometimes only have one swing at the issue, but if the judge takes a different slant than anyone was expecting, providing those additional facts, I think, can be helpful. The other thing, I think, if I'm arguing proportionality as a responding party, I want to make it digestible, right? Not so esoteric in gigabytes and process rates and review rates and illusion testing. I want to make it something that is actionable by both my opponent to understand where I'm coming from, and hopefully we can resolve most of these disputes. But if I can't, then make it actionable for the judge to say, Your Honor, if you add 10 more custodians, it's going to cost $1 million more. Or if you add these 5 file shares, it's going to cost, you can have all the numbers there, but explain the incremental change in what you're asking, right? In a way that is understandable instead of, I've seen sort of charts upon charts upon charts that I think doesn't present the issues in a way that make the concerns about the discovery tangible from a proportionate way. And simply saying, well, Your Honor, it's going to cost millions is a great way to lose your credibility in front of the judge. With that, I was going to blend right into the meet and confer process, which probably in some way should have gone before bringing it to the judge, right? Because that's really the heart and soul of this, in my view. I resolve upwards of 98% of my discovery disputes with my opponents in meet and confer. And that's the way it should happen. I mean, discovery is self-executing. I think 2 thoughtful lawyers who are zealously advocating for either side should be able to reach agreement, except where there's a real principle difference that they can't agree on, whether it's on relevance or proportionality or whatever else, privilege, possession, custody, and control. I think you need to come prepared for those conversations. I think that if the requesting party says, well, I don't agree with your objections, they should say why. And so you can be prepared to answer those. I think it should be a conversation. Not being prepared, you'll lose all credibility with your opponent who thinks you're just stalling and obstructing for no good reason. I do think that the level of due diligence changes as the interest from the other side changes, right? If your opponent, and I've had this happen, right, asks in a document request, please produce all databases and stop. That's not a particularly great request, not done with reasonable particularity under Rule 34. My response to that's going to be not as vague, but it's not going to have the same level of detail that I would with a very specific request and have to explain why I would be limiting that request. And that I think is an understandable, and that happens often in the meet and confer space. But as your opponent explains to you why they have an articulable, concrete reason that they really need this evidence because it will really help them explain or advocate for their side of the story, then if you think it's disproportionate, it's incumbent upon you to better articulate with real facts why you think, look, we can get that over here. There's an alternative location for this, or you already have it. Look here. Or I appreciate you think that's really important, but going through the Splunk logs of my firewall is going to be extraordinarily expensive, and here's why. The only thing I will add on top of this before turning it back over is I think it's very important for judges to think about the meet and confer process. I always see it as I want to go in front of the judge if we don't reach agreement, looking like the most reasonable person in the room. And I think if both sides are taking that position, you often reach agreement, right? And I think one of the cases that I would ask people to think about is the Boston Scientific v. Lee case that Judge Greenwald entered in 2014, actually on a subpoena. And I think the thing that decision teaches me is that it really incentivizes meet and confer. Because what the judge there said was, if you want to be flexible and reach agreement, do so before you get into my courtroom. Don't use your fallback position to say, well, they offered X, can I at least have X, right? That doesn't disincentivize, because it just means the other person keeps moving closer to you, and you can take a very unreasonable position knowing that you can always fall back on the reasonability of your opponent. And so to incentivize good meet and confers, I would recommend that you don't allow either side, responder or requester, to fall back on their opponent's most reasonable position if they're not willing to compromise and cooperate in the process.
Thanks, David. When I think about meet and confer process. I think that the first highlight that of the amended rules would be that I really like to take advantage of the Rule 26D, deliver discovery requests in advance of the Rule 26F conference. I know sometimes that isn't well taken by opposing counsel, and I've done it, but I just think it really can make the Rule 26 conference so much more productive if opposing counsel knows where you're going with discovery. So I've tried to make that one of my best practices. A few other things that I think are really important to keep in mind that I think have been addressed by the guidelines and the revised guidelines in a nice way are a few different issues. One is where ESI is going to be used. And Dave and I have discussed this and had some agreement and some disagreement, but it's really helpful to me to understand and have opposing party come to the table prepared to provide information about its electronic systems, about what data is out there, what platforms it's using, if it's contending any of the data is inaccessible, if the databases are going to be extracted and produced, what are the fields in the database? Are there any fields that are being withheld? And if so, why? And just having that general discussion about the relevant systems. I know when Dave and I were discussing it, he voiced concern that, you know, does serving discovery really entitle plaintiffs to knowing every bit about, you know, every piece of information about all electronic systems by the defendant? We can probably agree to disagree somewhat on that, but I don't think that's my position. I think that, you know, of course, relevancy is going to have a role in what electronic systems exist and have the potentially relevant information. But I think an exchange of that information early on builds trust and also allows me as the requesting party to better understand any burden arguments that might be made. You know, that's additionally, if there's going to be TAR or search terms used, which is common in larger cases, a discussion about how the responding party intends to go about doing that, if they're using search terms, if they're going to be proposing and negotiating those search terms with opposing parties so that we can have feedback on those terms. All of these issues are really important to discuss in the meet and confer process. And again, can get things off to the right start instead of having a lack of transparency creates distrust, which is never going to be helpful in the discovery process. That said, I think it's also important to remember that, and I think this is one of the points that is made in some of the revisions. I think it's best practice number 2 points out some of these issues, that regardless of those types of exchange of information, the responding party still has an obligation under Rule 34 to conduct a reasonable inquiry in response to any discovery request. I don't have insight into the sources of information and whether it be custodial or non-custodial sources or even search terms, how to best identify and produce the responsive documents. Only my opponent, the responding party, has true access to that information. So one thing I wanted to point out with best practice number 2, which I think is really helpful, is it acknowledges this. And it says just because a party is considering using technology, whether it be TAR, search terms, or other techniques to assist in its review, this does not relieve the party of its duty to produce discovery that is relevant, accessible, and that can be produced without TAR and search terms. Importantly, the new guidelines also recognize that many relevant documents can be retrieved without such techniques. These might be policy documents. These might be transactional data. Not always, and David and I have also discussed and had some disagreements around this, but oftentimes these types of documents are the location is known. They are obviously responsive and discoverable. And if that information is available and responsive, it should be produced promptly. And this is recognized in best practice number 2. And it should not be subject to being withheld pending development of a robust ESI protocol. In larger cases, negotiating the ESI protocol can sometimes take months. And so what best practice number 2 in its revisions recognizes is that we don't have to have a complete ESI discovery plan to get discovery that the parties agree is core, accessible, and discoverable moving, and that should start moving and allow the parties to begin preparing their cases earlier rather than later. So I think those are some of the important things I think about during the meet and confer process, and I just wanted to highlight some of the ways in which the revised guidelines have acknowledged some of the issues that I, as the requesting party, have faced, and that might be helpful in thinking about during that process. And that kind of rolls into the next topic, which I'll just touch on briefly again, are the topic of non-custodial sources and maintenance of business records. As I just discussed from best practices number 2, frequently these sources are not sources that require the negotiation of search terms to be complete, or an ESI protocol to be complete before the responding party can start identifying the responsive documents and producing documents without delay. And another addition to the new guidelines under best practices number 6 continues to acknowledge this concept. And it says, that a detailed discovery plan should not delay the production of documents the parties agree are responsive to a production request, relevant and accessible. If the parties cannot begin production of documents that have not been objected to prior to the completion of the discovery plan, they should promptly seek resolution by the court. So that's a strong message, I think, that where there are business records available, where there are non-custodial sources, where say transactional data exists, that you can move forward with those issues as you're developing a more complex, perhaps ESI protocol. One other thing I would raise that I meant to raise with respect to the meet and confer is also an addition to best practices number 4, which talks about identifying issues that can be eliminated at the meet and confer process. And one really helpful addition is that the parties should consider authenticity agreements, at the outset. This can really reduce the discovery burden, agreeing that business records will be authenticated, perhaps social media produced by the plaintiff can be considered authentic at the outset. That's another issue that I think can be really helpful. David, I'm going to turn it over to you to respond and add to those comments on these sources of data.
Sure, I'm going to go quickly because I think we're coming toward the end of our session, and I do want to get at least to search terms. So I'm just going to say we do disagree in this space. We disagree in this space. I don't read the guidelines exactly the way you do. I think obvious is in the eyes of the beholder. I do think that the idea of producing, while I'm still formulating the scope of discovery, where I agree, yes. Where I don't agree, not so much. And in my experience, there's relatively limited agreement at that stage, particularly when I may not understand even the complaint that's been filed against my client. I will also say it is uncommon in my experience for large organizations to have it so organized that they don't need to do some searching, that they know exactly where something is or the complete set of something is. Even for, as you say, transactional records, the scope of what might be relevant or at issue may be wildly in dispute, and going back and interrupting the business to get those records is a non-trivial exercise. So I find that at the beginning of the stage, it's hard to do sort of that preliminary discovery that you're asking for. and not proportionate, and increases costs unnecessarily. And I find, it's that I have a hard time getting the similar discovery, social media, medical records, other important things from individual plaintiffs. And that can get delayed well past when I'm doing my initial rounds of productions. I'm going to turn to search terms because you mentioned those as part of meet and confer, and they often are part of meet and confer along with TAR. I will say that overly rigorous ESI protocols, in my view, are actually generally anti-proportionality because they don't allow good lawyers to react to the actual data that they're often entered into very early in cases when people don't know where the data is going to lead them. As my good friend Browning Marin once said, no discovery plan survives first contact with the data. Search terms, I think, and all filtering, but I'm going to focus on search terms because even though I'm a devotee of TAR and use TAR all the time, I also use search terms almost all the time. They are an amazing source for proportionality. And the reason I say that is there's no such thing as a good search term. A word unto itself is neither good nor bad as a search term, but only in context. And so as I measure recall and precision and I develop those terms and I take in suggestions from my opponent about what terms I should use, I can determine on a marginal basis, which is the last factor in proportionality, about marginal cost and marginal benefit. If a word brings back no responsive or relevant documents, it's not proportionate. I don't care how many non-responsive, it's not helping me. If it only brings back a few, but brings back thousands or hundreds of thousands of non-responsive documents, also not helpful. So, you can weigh in that marginal case how good a search term is. Now, that doesn't mean I don't use any search terms. I got to come up with a way to find the documents. But I do think you can document it. It helps show your opponent, like, hey, you want me to use this word. It's not bringing back anything useful. And there does need to be an acceptance of some level of transparency that you can show the evidence of what you're doing. Doesn't mean you show the non-responsive documents, but the statistics, the metrics, I think are valuable things to help bridge those gaps as part of using search terms. Here's a red flag that I see in tons of cases that I don't think gets enough appreciation from the parties or the court. Because of the practice that I lead, I tend to work in very, very large matters with multiple defendants and multiple plaintiffs of various different types in the matter, right? And by the way, can be corporation versus corporation, not asymmetric. And everyone will agree to one set of search terms that can be used against all the defendants. Any judge who sees that, in my view, should get a giant red flag, because those search terms are going to act very differently on all of those different corporations, right? They talk in a different way. They have different products. They have different ways of doing business. They may have different languages, different systems. The length of time they keep data may be very different. And so that the idea that one set of search terms would work proportionally for all of the parties is extremely unlikely. But it's something that we see all the time for administrative ease. And I just think that if we're going to have these cases where we think it's the best set of resources to do these large cases with all these defendants and all these plaintiffs, then we need to do the work to understand that the way they undertake their discovery is going to be different. And we should work that through. There may be terms that are used across all the parties, but maybe with different limiters or different expanders, depending on how they actually work in those actual cases. You would never think about using the same custodian in all those, right? There's John Smith in all of those defendants. We wouldn't pick that John Smith. We pick them by role and operation and where we think the relevant information is. Search terms are the same way. And I think that would go a long way, along with a good effective use of TAR, as Judge Peck has often opined on, will help us deal with the ever increasing explosion in data.
Yeah, I just to comment on some of the things you said about applying search terms. I agree. I think transparency is great, but one that the tension with that is that as a requesting party, I want to make sure that the responding party doesn't use that to absolve themselves of their responsibilities under Rule 34 to, reasonably respond to discovery in good faith. So, for example, as I mentioned before, the responding party is in the best position to identify what search terms will be effective because they know the terminology used within their business. But plaintiff's counsel also wants to be able to weigh in on those. And David, I agree that sharing the results of the search term hits and having that be a more iterative process is a good one, because then you increase the trust. It's not just, okay, I ran these search terms, you agreed to them, you have to live with them, and you never know if they were effective, and too bad you said, okay, so I don't have any other responsibilities, versus, no, I don't want to run these search terms, but I'm not going to show you the data. So I think the iterative process is very important to make sure that both parties are feeling comfortable with moving forward, especially when search terms are at play.
Mind if I respond to that quickly? I think, so 2 parts there. One, the default, and the default is requesting parties make a request. I have an ethical and legal obligation to do reasonable discovery. And if nothing else happens, I still have that obligation. If I mess that up, I don't want to be in front of Judge Rosenthal or Judge Grimm, right? That's not going to go well for me, right? However, if we want to cooperate and reach transparency, then if the requesting party wants that level of transparency, at the end, there has to be surety from my side that if I do those things, I've complied with discovery. If I've acted in good faith and I do the things that we've agreed to, so if we've agreed to 100 search terms and I'm allowed to use TAR, and I'm gonna meet and confer with you on TAR, and maybe I share the results of my null set testing, that's it. You don't get additional discovery. I don't have to go out and keep looking to see if there's something there. We've agreed to the metes and bounds of the effort I need to put in to look for the documents we've agreed to look for. And I actually think this is maybe the other big issue that I find so often undermines meet and confer and undermines decisions before the judge. We fight about the search terms and we discuss the search terms without ever realizing what are we actually looking for. Like if we don't agree about what's responsive, then all of my testing in the world won't help me because the search terms are unmoored from what they're looking for, because the search term's only as good as if it finds what's supposed to find and throws out what's unuseful. So if we don't agree and don't have that conversation about what your requests are and what my responses mean, and therefore what am I looking for, any agreement on search terms is sort of unhinged from the reality of what the discovery should be doing, which is finding the facts to enable us to resolve the dispute either before trial or at least present to the finders of fact at trial.
Well, we could debate this all day, but I see that we're out of time, so maybe we'll talk offline.